Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers dispelling reasonable suspicion, visual estimates of speed, and license checks, and is brought to us by Last American Patriots channel. Be sure to check out the description below and give them the credit that they deserve. On June 3rd, 2022, Officer Gilpin of the Midland Police Department pulled over the owner of the Last American Patriot YouTube channel, who we will refer to as Mr. Patriot, because he believed that Mr. Patriot had his phone out while driving. However, Mr. Patriot's cell phone was actually mounted on the dashboard of the vehicle. As Officer Gilpin approached the driver's side window of the vehicle, Mr. Patriot began to film the interaction.
Sir, I'm Officer Gilpin, Midland Police Department, sir. Ma'am. And so the reason why you got pulled over, as you passed me, I noticed you had your phone up.
No, my phone's right here.
Well, maybe it was my mistake then I stand corrected.
Have a good day.
No, you're not free to go. You seem to be in a hurry, sir.
Was I speeding?
Yes, you were.
No, I was not.
Okay, you weren't speeding?
No, sir.
All right, your license, please.
Do you have me clocked for speeding, or did you pull me over for that? Because that's the first time you told me you pulled me over for that. Now you're telling me speeding.
Let me start over. Okay.
Please do.
I said I noticed you with your phone. You corrected me. You said your phone was us up. You
So
didn't have your phone in your hand, so I was mistaken.
So then you got me for something else now.
Yes, sir. Okay.
You have a supervisor?
I do have a supervisor. So
Why don't you get him out here?
Your license, please.
What did you clock me at?
Sir, I did not clock you.
Exactly. So I wasn't speeding. Because I saw you whenever I turned off of Garfield. And I am obviously not going to speed past a cop. Whenever I passed you, I was going 16 miles an hour. It's 25 on these roads, 20 or 25 on these roads.
My supervisor is quite a distance away. I'm going to give you a warning and let you go. You want to talk to me, supervisor?
Great.
All right, I'll call my supervisor.
So you're holding me here...
You asked for a supervisor.
Because you're asking for my license for no reason, because I wasn't speeding. I'm not going to give you my license unless I was speeding.
All right, so you want to...
So if you're good with it and I can drive away, I don't need your supervisor. Okay. But if you want my license and you're going to violate my Fourth Amendment, you're absolutely getting your supervisor.
Do you want me to call my supervisor?
Do you want my license?
Yes, I want your license.
Yes, supervisor. Okay.
After Mr. Patriot demonstrates that he was not using his phone, Officer Gilpin then claims that Mr. Patriot was speeding, even though he did not clock him at any speed. And Mr. Patriot argues that he does not have to show his driver's license because Officer Gilpin was wrong about the phone and he was not speeding. We will discuss the validity of visual estimates of speed later in this episode, but even assuming that the only basis for the stop was the cell phone, courts are split as to whether an officer can request identification after the reasonable suspicion that is the basis for a traffic stop is dispelled. In general, as the Supreme Court detailed in the 1983 case of Florida versus Royer, quote, an investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. Similarly, the investigative methods employed should be the least intrusive means reasonably available to verify or dispel the officer's suspicion in a short period of time. Based on this reasoning, some courts have concluded that an officer must terminate a traffic stop as soon as their suspicion is dispelled. For instance, in the 2001 case of U.S. versus Valadez, the Fifth Circuit Court of Appeals, which has jurisdiction over the state of Texas, held that an officer could not continue to detain an individual he had stopped on suspicion of an expired vehicle registration sticker and illegal window tinting in order to run a computer check for his criminal history after determining that both the registration and the window tint complied with the law. In reaching this conclusion, the court explained that, quote, once an officer's suspicions have been verified or dispelled, the detention must end unless there is additional articulable reasonable suspicion. Further detention was not lawful after the point at which the purposes of the stop was resolved. However, in the 2015 case of Rodriguez versus United States, the Supreme Court established that in addition to determining whether to issue a traffic ticket, an officer's quote-unquote mission includes, quote, ordinary inquiries incident to the traffic stop, such as checking the driver's license, determining whether there are outstanding warrants against the driver, and inspecting the automobile's registration and proof of insurance. And some courts have used this case to authorize officers to complete these ordinary inquiries after all reasonable suspicion has been dispelled. For example, the Supreme Court of Wisconsin held in the 2018 case of State versus Smith that, quote, when an officer conducts a valid traffic stop, part of that stop includes checking identification, even if the reasonable suspicion that formed the basis for the stop in the first place is dissipated. Asking for a driver's license does not impermissibly extend a stop because it's part of the original mission of the traffic stop. Similarly, in spite of the Fifth Circuit's holding in U.S. versus Valadez, the Third District Court of Appeals of Texas determined in the 2009 case of Anderton versus State that after an officer's suspicion was dissipated, quote, it does not follow that the officer acted unlawfully by continuing to detain appellant after realizing his mistake. During a routine traffic stop, an officer may demand identification, a valid driver's license, and proof of insurance from the driver, and the officer may detain the driver in order to check for outstanding warrants. Given the split between courts on this issue, it is nearly impossible to predict how a court reviewing this issue would decide. But Mr. Patriot certainly has a strong argument that Officer Gilpin could not continue to detain him after his suspicions were dispelled without violating the Fourth Amendment.
So those are fellow officers, not my supervisor. Supervisor outside town, so he's coming over, okay?
Great use of resources there.
I'm sorry?
Great use of resources there.
Okay, you asked for a supervisor, so.
Well, because you're trying to violate my Fourth Amendment.
Sir?
Are you or are you not? Why do you need my license if I wasn't speeding? If I didn't commit an infraction, why do you need my license?
Visually.
You can't pace from sitting still.
Visually, you came up rapidly behind me. You were speeding. My interpretation, I didn't get your radar, so that is why I told you were speeding. Okay?
You don't know that, so you
talk?
don't get my license.
So I'm driving. I saw you behind me. I saw the phone up. I thought you had your phone in your hand. Okay? So I pulled you over because of the phone. You said it was on the monitor. I said, sir, I stand corrected. Exactly.
Have a good day. You're on your way.
No, and I said you were speeding. You said we're going to start over. That's where
we're starting over, but you're still wrong. We can start over,
sir,
but you're still wrong.
You can be right. We can all be
okay.
Going back and forth. I'm just explaining. You asked me to start over.
Okay.
I'm just saying what I saw and what I interpreted. And I did not get your radar. You're exactly right. I did not.
Okay.
So I said you were speeding. I asked your license. You said no. You said I'm violating your Fourth Amendment.
Absolutely.
I said, okay. You said you want a supervisor. I said, okay, I was going to give you a verb and let you go. I said, my supervisor's on the side of town. I can call him if you want the supervisor. And I did.
If you got to have that license, I want to talk to the supervisor.
And that's where we are. So,
how fast do you think I was going?
You're going over 10% over the speed limit.
You're out of your mind, bro.
Sir, my interpretation.
You're out of your mind. So if the speed limit here is it 20 or 25? I was doing 16. Is it 20 or 20? Is it 20 or 25 right here?
If you say you're doing 16, that is your interpretation.
Is it 20 or 25 right here?
I don't know. You tell me.
You don't know.
No, you tell me.
You don't. Either way. So if it's 20,
25,
10% over would be 22.
If it's 25, 10% over is 2.5 miles.
Yeah. Okay, so 27.5.
Yeah.
So you visually saw me going 27.5 miles an hour.
Yes, sir.
You need to get recalibrated, man.
Officer Gilpin claims that he visually estimated that Mr. Patriot was driving 10% over the speed limit, despite the fact that he did not know what the speed limit on the road was. Mr. Patriot later determined that the speed limit on the road was actually 30 miles per hour, so 10% would have been 3 miles per hour over the speed limit. Courts generally recognize that visual estimates can provide an officer with reasonable suspicion to conduct a traffic stop in some circumstances. For instance, in the 2008 case of Simpson versus State, the 7th District Court of Appeals of Texas stated that, quote, a police officer does not need to know the exact speed at which an automobile is traveling in order to make a stop for a traffic violation, and that, quote, an officer's visual estimate of a vehicle's speed may be sufficient to give an officer a reasonable suspicion to stop the vehicle. Similarly, in the 2018 case of Emerson versus State, the 5th District Court of Appeals of Texas noted that, quote, an officer's visual estimates of speed can suffice to establish reasonable suspicion to conduct a traffic stop. Still, as the 4th Circuit Court of Appeals explained in the 2012 case of United States versus Sowards, quote, the Fourth Amendment does not allow, and the case law does not support, blanket approval for the proposition that an officer's visual speed estimate in and of itself will always suffice as a basis for probable cause to initiate a traffic stop. Instead, for the purposes of the Fourth Amendment, the question remains one of reasonableness. The court went on to explain that, quote, critically, the reasonableness of an officer's visual speed estimate depends, in the first instance, on whether a vehicle's speed is estimated to be in significant excess or slight excess of the legal speed limit. If slight, then additional indicia of reliability are necessary to support the reasonableness of the officer's visual estimate. Accordingly, although visual estimates of speed can sometimes be sufficient for an officer to prove they had reasonable suspicion to conduct a traffic stop, in this situation, a court would likely conclude that Officer Gilpin's assertion that Mr. Patriot was speeding was not reliable enough for him to have reasonable suspicion, as he claimed that he estimated the speed was only 10% over the speed limit, and he admitted to not even knowing what the speed limit was.
There's no argument. I'm telling you what the truth is. I'm being molested by my government for doing nothing wrong because you have to have my ID.
Because you violated traffic offense, yes.
No, I didn't.
Again, your interpretation.
You're a liar, dude. Don't come back up to this car. Get your supervisor. I'm not talking to you anymore. Not talking to you anymore. You're a liar.
Yes, sir.
Sir, how you doing?
What can I do for you, man?
I'm wondering why I'm still here.
Well, apparently you called for a supervisor.
Because he wants my license when I have committed no traffic infraction. When your officer first got up to this vehicle, he said he pulled me for this.
Okay.
Because that's up there. When that was wrong, then he tells me that I'm speeding. I know for a fact I wasn't. I looked down at 16. The whole time I was behind him and past him, I looked down, I was 16 miles an hour.
Okay.
But he wants to get my license. He already told me, he hasn't clocked me. He estimated my speed from a standstill, which you can't pace from a standstill. He says I'm going 10% over the posted speed limit.
Okay.
From a standstill, he knows this. I'm not giving up my license unless you're threatening to take me to jail.
Okay.
I'm not the war you guys want right now with all y'all have going on. I was going 16 miles an hour, but I'm not going to let him violate my Fourth Amendment when he was wrong.
Okay. So what do you want now? What is it that
I want to be unmolested from my government and on my way.
Okay.
It's not funny.
Well, I mean, you sat here waiting for me.
Because he wouldn't let me go.
Okay. All you need to do is verify that you have a driver's license.
Not going to do it. He doesn't have a reason to see it.
Well, now, yeah, actually, we do have a reason to see
What
it.
reason is that?
Because we can actually stop you to check your driver's
No,
license.
you can't.
Yes, we can.
Not unless I've committed an infraction.
We actually can. I searched the traffic code. It'll tell you right there.
Officer Wilson claims that the Texas Traffic Code allows officers to stop individuals just to check their driver's license, implying that no other basis for the traffic stop is needed. Section 521.025 of the Texas Transportation Code requires that, quote, a person required to hold a license shall have in the person's possession while operating a motor vehicle the class of driver's license appropriate for the type of vehicle operated, and display the license on the demand of a peace officer. The statute also states that, quote, a peace officer may stop and detain a person operating a motor vehicle to determine if the person has a driver's license as required by this section. While this provision does seem to allow officers to stop any driver to simply check if they have a driver's license, the Supreme Court has long held such practices to be unconstitutional. In the 1979 case of Delaware versus Prowse, the court explained that, quote, an individual operating or traveling in an automobile does not lose all reasonable expectation of privacy simply because the automobile and its use are subject to government regulation. Were the individual subject to unfettered governmental intrusion every time he entered an automobile, the security guaranteed by the Fourth Amendment would be seriously circumscribed. The court then went on to hold that, quote, except in those situations in which there is at least articulable and reasonable suspicion that a motorist is unlicensed or that an automobile is not registered, or that either the vehicle or an occupant is otherwise subject to seizure for violation of law, stopping an automobile and detaining the driver in order to check his driver's license and the registration of the automobile are unreasonable under the Fourth Amendment. Persons in automobiles on public roadways may not, for that reason alone, have their travel and privacy interfered with at the unbridled discretion of police officers. In another 1979 case, the Supreme Court summarized in Brown versus Texas that, quote, the reasonableness of seizures that are less intrusive than a traditional arrest depends on a balance between the public interest and the individual's right to personal security free from arbitrary interference by law officers. A central concern in balancing these competing considerations in a variety of settings has been to assure that an individual's reasonable expectation of privacy is not subject to arbitrary invasion solely at the unfettered discretion of officers in the field. To this end, the court concluded that, quote, the Fourth Amendment requires that a seizure must be based on specific objective facts indicating that society's legitimate interests require the seizure of the particular individual, or that the seizure must be carried out pursuant to a plan embodying explicit neutral limitations on the conduct of individual officers. Therefore, despite the apparent meaning of Section 521.025 of the Texas Transportation Code, officers are prohibited by the Fourth Amendment from stopping individuals without reasonable suspicion to check their driver's licenses.
But that's all he wanted to verify. He's going to send you on your way.
No.
So, go. I'll let you go. Go.
Thank you very much. What's your name?
Wilson.
Wilson. Badge number?
330.
Thank you, sir.
330.
Thank you.
After Mr. Patriot again refused to show his driver's license, Officer Wilson allowed him to drive off. The day after this incident, Mr. Patriot created his YouTube channel in order to share the footage of this encounter. It is unclear whether he intends to take any further action regarding the interaction. Overall, the Midland officers get a C- for claiming that Mr. Patriot was speeding when Officer Gilpin didn't even know the speed limit, attempting to identify Mr. Patriot without reasonable suspicion, and demonstrating a fundamental misunderstanding of the Fourth Amendment limitations on when officers can detain citizens. While this grade may seem generous, given the officers' blatant disregard for both the truth and the Constitution, I believe it is important to acknowledge that we have reviewed similar interactions on this channel that ended in a much less peaceful resolution, and the Midland officers never threatened Mr. Patriot with arrest progressed or escalated the situation into a physical encounter, maintained a respectful demeanor throughout the interaction, and eventually allowed Mr. Patriot to leave without checking his driver's license. That being said, the officer's behavior was in no way commendable, and I urge these officers to educate themselves on the rights granted to citizens by the Fourth Amendment. Mr. Patriot gets an A+ for respectfully but firmly standing up for his constitutional rights, waiting for a supervisor instead of providing his driver's license, and taking steps after the interaction to share his experience with the general public. Before this interaction, Mr. Patriot was not an auditor or a constitutional activist, and many individuals in similar situations would simply hand over their driver's license rather than take the time to wait for a supervisor to arrive in order to defend their Fourth Amendment rights. I commend Mr. Patriot for having the courage, constitutional knowledge, and patience to call out the officer's lies and wait for a supervisor, and to stand firm in his refusal to provide his driver's license when there was no reasonable suspicion for the stop. And I encourage other citizens to learn from his example. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.